The unfortunate reality that we are facing now in America is that it is incumbent upon attorney generals to stand up and protect Americans from their president. Because time and time again, this president is acting unlawfully in violation of the Constitution.
I don't derive my citizenship from my parents. I became the first American citizen in my immediate family by right of my birth on American soil in Hartford, Connecticut. The 14th Amendment establishes who we are, that this is the soul of our country.
I think the historical record is much stronger in favor of President Trump's executive order than the 3 or 4 justices that commented about the merits were willing to accept.
So we survived until the 1960s without universal injunctions.
That's exactly correct. And in fact, those are very limited, very rare, even in the 1960s. It really exploded in 2007 in our cert petition in Summers against Earth Island Institute. We pointed out that the Ninth Circuit had started doing this in a whole bunch of cases involving environmental claims.
Let's assume that it's commonality because, they only target one portion of the order, right? In that circumstance, does the government get anything different? This is back to Justice Alito's question about what's it to you? What's the practical difference to you? Do you want to say anything about whether there's a practical difference between a universal injunction and a loss in the class?
So the technical problem here seems to be class-wide relief without the district courts going through the steps to assess whether a class should be certified, correct?
Correct.
Okay. And if you win here on this procedural point, it seems very likely that the day after there are going to be suits filed all over the place seeking class-wide treatment.
Let's just assume you're dead wrong. How do we get to that result? Does every single person that is affected by this EO have to bring their own suit? Are there alternatives? How long does it take?
And let me just turn your attention to one other thing, because the real concern, I think, is that your argument seems to turn our justice system, in my view at least, into a catch-me-if-you-can kind of regime from the standpoint of the executive, where everybody has to have a lawyer and file a lawsuit in order for the government to stop violating people's rights.
State lines. And then the last point is, we've never in this country's history since the Civil War had your citizenship turn on when you cross state lines. So we don't have answers to these workability questions, not just because it wasn't presented in the district court, not just because it's 2 sentences in an emergency application, but because for over a century, executive practice has been uniformly to the contrary, building on this court's decision in Wong Kim Ark. So we genuinely don't know how this could possibly work on the ground.
Shouldn't we grant cert before judgment on that issue? If we're afraid that this is, or even have a thought that this is unlawful executive action.
If I were in your shoes, there is no way I'd approach the Supreme Court with this case. So you just keep on losing in the lower courts, and what's supposed to happen to prevent that? So, let's say that we're an individual person even. Let's say it wasn't a class. And goes up and gets a ruling from the Second Circuit that the EO is illegal. Does the government commit to not applying its EO in the entire Second Circuit? Or does it say, no, we can continue to apply the rule as to everybody else in the Second Circuit?
I can't say as to this individual case. Generally, our practice is to respect circuit precedent within the circuit, but there are exceptions to that.
Yes, that is generally your practice, and I'm asking whether it would be your practice in this case.
I can't answer because it would depend on what the lower court decision said. So there are circumstances, as I was suggesting, where we think that we want to continue to litigate that in other district courts in the same circuit as well.
Suppose that there's a single person who brings a suit, and it gets all the way up to us after 3 or 4 or 5 years. And we say, we really do agree with those 4 precedents that Justice Sotomayor started with, and your EO is illegal. Is that only going to bind the one guy who brought the suit?
No, that would be a nationwide precedent that the government would respect.
So finally, once it gets to us after 4 years, you're going to respect that?
Yes.